As we move into the final week of January 2026, the United States Supreme Court has maintained 3 months of deliberate silence on what may prove to be the most consequential economic ruling since the court's intervention during the Great Depression. On November 5th, the justices heard 3 hours of oral arguments challenging President Trump's sweeping tariff regime imposed under the International Emergency Economic Powers Act. Since that day, markets have waited, businesses have filed over 1,000 refund claims, and hundreds of billions of dollars hang suspended in legal limbo while the 9 justices deliberate behind closed doors. The silence is not accidental. The delay is not procedural. What appears as judicial patience is actually the structural acceleration of a systemic fracture that most observers fail to recognize until the moment of rupture arrives. I'm not a financial advisor. This isn't financial advice. This is an educational analysis based on publicly available information and historical precedent. The scale of what hangs in the balance defies casual comprehension. Reported data indicates that tariff collections under the International Emergency Economic Powers Act generated approximately $129 billion through December 2025, with total tariff revenue for fiscal year 2025 reaching $287 billion, representing a 192% increase over the prior year. The federal government collected $151 billion from customs duties in just the second half of fiscal year 2025 alone, a nearly 300% increase over the same period in 2024. Industry estimates suggest that if these tariffs remain in effect through 2035, they could generate approximately $2 trillion in conventional revenue, or roughly $1.2 trillion after accounting for negative economic impacts on income and payroll tax collection. This is not a minor trade dispute. This represents a fundamental restructuring of how the American government funds itself, positioned as the largest tax increase as a percentage of GDP since 1993, pushing the average effective tariff rate to 10.1%, the highest level since 1946. But here is what makes the Supreme Court's silence so structurally significant. The lower courts have already ruled. Both the Court of International Trade and the Federal Circuit Court of Appeals determined that the International Emergency Economic Powers Act does not authorize the president to impose tariffs. Those rulings were explicit, unambiguous, and grounded in constitutional separation of powers. The tariffs remain in effect only because the Supreme Court granted a stay pending appeal. The justices did not grant that stay because they found the government's position compelling. They granted it because invalidating $200 billion in revenue collection midstream while the case proceeded would create administrative chaos. The stay was an act of procedural caution, not substantive agreement. Yet that procedural caution has now extended for nearly 3 months since oral arguments, and the silence grows heavier with each passing week. During those November oral arguments, the skepticism from the bench was palpable and bipartisan. Chief Justice Roberts noted that the statute says nothing about tariffs and pressed the Solicitor General on how the power to tax, which the Constitution explicitly reserves to Congress, could hide inside regulatory language about regulating importation. Justice Sotomayor challenged whether tariff authority could be implied from general emergency powers, suggesting that under the government's theory, any president could declare a climate emergency and restructure the entire economy. Justice Gorsuch pushed even harder, asking whether the executive's claimed inherent authority in foreign affairs could extend to declaring war, another power the Constitution explicitly assigns to Congress. Justice Barrett focused on the practical nightmare of reimbursing billions already collected. Justice Kagan emphasized that actions of vast economic and political significance require clear congressional authorization under the major questions doctrine. Even justices traditionally deferential to executive power in national security matters appeared troubled by the sweeping nature of the claimed authority. The government's position rests on an interpretation so broad it would render congressional authority over taxation nearly meaningless. The administration argues that the phrase regulate importation in a 1977 statute designed to narrow presidential emergency powers somehow grants unlimited authority to impose tariffs of any magnitude on any country for any declared emergency. This interpretation faces a fundamental problem. The International Emergency Economic Powers Act was enacted specifically to constrain the expansive powers presidents had exercised under the Trading with the Enemy Act. Congress deliberately narrowed those powers in 1977, adding procedural checks, including congressional reporting requirements. The statute's legislative history makes clear that Congress intended to limit, not expand, presidential authority. In the nearly 50 years since IEEPA's enactment, spanning 67 separate national emergency declarations by presidents of both parties, not one president until now claimed the statute authorized broad tariff imposition. This historical practice carries substantial weight in statutory interpretation. When a claimed power goes unused for nearly 5 decades, despite numerous opportunities and incentives to employ it, that silence speaks to original understanding. The constitutional dimension cuts deeper still. Article 1, Section 8 of the Constitution assigns the power to lay and collect taxes, duties, imposts, and excises exclusively to Congress. This is not a peripheral authority. The founders considered the power to tax the single most important check on executive authority, the core mechanism by which the legislature controls the executive branch. The entire Revolutionary War was fought over taxation without representation. The Constitution's text could hardly be clearer on this point. Yet the government's position in this case asks the Supreme Court to accept that Congress silently delegated this core constitutional power through vague language in an emergency statute that doesn't mention tariffs, duties, or taxes anywhere in its text. Under the major questions doctrine, which this Supreme Court has applied aggressively in recent years to strike down agency actions on issues like student loan forgiveness and vaccine mandates, such momentous delegations require crystal clear congressional authorization. What makes this moment structurally dangerous is the convergence of fiscal necessity with legal instability. The Trump administration has made these tariff revenues central to its fiscal planning. The tariffs were marketed as substitutes for income taxation, mechanisms to fund government operations without traditional tax increases. Treasury Secretary Bessent has stated publicly that the government expects to collect these revenues and has incorporated them into deficit projections. The One Big Beautiful Bill Act, which restructured substantial portions of federal taxation and spending, was predicated on the assumption that tariff revenues would offset much of the deficit impact. Industry analysis suggests the tariffs counter approximately 2/3 of the primary deficit impact over 5 years, or 4/5 over 10 years. Remove those revenues suddenly, and the federal government faces an immediate fiscal hole measured in hundreds of billions annually. This creates the structural trap. The Supreme Court cannot rule based on fiscal convenience. The justices cannot uphold constitutionally dubious claims simply because striking them down would create budget problems. That would subordinate constitutional structure to administrative expediency, precisely the kind of reasoning that leads to systemic collapse. Yet the practical consequences of invalidating these tariffs are genuinely severe. Over 1,000 companies have already filed protective refund claims with the Court of International Trade, positioning themselves to demand reimbursement the moment the Supreme Court rules against the government. The refund process itself could take years to administer. Trade attorneys have estimated that processing refunds could overwhelm the customs system and take up to 2 years, even with streamlined procedures. Meanwhile, businesses that absorbed these costs have squeezed margins rather than passing full costs to consumers. The economic relief consumers expect would be delayed substantially, even in the best-case scenario. The administration has stated that if the Supreme Court rules against them, they have backup plans ready. Treasury Secretary Bessent mentioned at least 3 alternative authorities under the 1962 Trade Act that could be deployed to maintain most tariffs. Section 232 National Security Investigations and Section 301 Unfair Trade Practice provisions remain available and unaffected by any ruling on IEEPA. The administration has already begun using Section 232 more aggressively, imposing 50% tariffs on steel, aluminum, and copper, and 25% tariffs on automobiles from most countries, all under national security justifications. This means that even if the court strikes down the emergency tariffs, replacement tariffs could be in place within days or weeks, though through more procedurally constrained pathways. Here is where the silence becomes telling. The Supreme Court was expected to rule before the end of 2025. Many analysts predicted a decision by early January. Markets have been on edge expecting the ruling each time the court announces opinion days. Yet decision after decision passes with no tariff ruling. The court issued opinions on January 9th, January 14th, January 20th. Each time the tariff cases were not among the decisions released. The court has now begun a 4-week recess and will not return to the bench until February 20th. This means the disputed tariffs will remain in place through at least mid-February, nearly 4 months after oral arguments, for a case the court agreed to hear on an expedited basis, for a case involving hundreds of billions of dollars in revenue and affecting virtually every import into the United States. This delay is extraordinary. Historical patterns suggest what this delay actually signals. The Supreme Court has a documented tendency to wait until presidents lose some of their post-election political capital before delivering major legal defeats. When the court handed Richard Nixon his final devastating loss, requiring him to turn over the Watergate tapes, it came after his approval ratings had collapsed. When the court struck down major Bush administration policies on detention of suspected terrorists, those rulings came in the second term. When the court invalidated Obama administration immigration policies, the decision arrived as his presidency wound down. The court handed Biden significant defeats on student loan forgiveness after his approval ratings had declined substantially. This is not coincidence. The justices are acutely aware of political cycles and the court's institutional position. They understand that ruling against a president at the height of political power invites confrontation and potential institutional damage to the court itself. President Trump started his second term with relatively positive approval ratings, but recent polling shows those numbers declining throughout 2025. The December NBC News poll showed 42% approval, with 58% disapproving. More significantly, the tariffs themselves have become politically toxic. Industry data shows that ocean container volumes to the United States are down 14% year over year. Imports from China fell 28% in 2025, while exports to China declined 38%, representing one of the sharpest bilateral trade contractions in recent history. Job growth collapsed after the Liberation Day tariffs were announced in April. Employers added only 584,000 jobs in 2025 compared to 2 million in each of the prior 2 years. Healthcare and social assistance accounted for virtually all private sector job growth, meaning that absent those sectors, the economy essentially stopped adding jobs. The unemployment rate rose 0.3 percentage points by year-end 2025, with estimates suggesting an additional increase by the end of 2026. Consumer sentiment hit its lowest level in 12 years. This is the environment into which the Supreme Court will eventually issue its ruling. The tariffs have generated revenue, but at catastrophic economic cost. Trade relationships have fractured. Supply chains have been disrupted. Businesses have pulled back on capital expenditures except in artificial intelligence infrastructure. Recent data analysis by the Kiel Institute found that foreign exporters absorb only about 4% of the tariff burden, while the remaining 96% passes through to American buyers. Even more striking, fertilizer importers saw pass-through rates exceeding 100%, meaning domestic prices rose by more than the tariff amount as suppliers used the tariff as cover to raise prices further. The notion that tariffs would make America rich by forcing foreigners to pay has collapsed upon contact with economic reality. The court's silence during this deterioration is strategic. Every week that passes, the political cost of maintaining these tariffs becomes clearer. Every data release showing weak job growth, every report of businesses struggling with tariff costs, every indication that consumers are bearing the burden. All of this builds the case that these tariffs are not the economic panacea they were marketed as. The court does not need to base its decision on these economic outcomes. The legal and constitutional issues are clear enough on their own, but the justices are not naive about the political and practical context in which their ruling will land. From a purely legal standpoint, the case against the administration's position is overwhelming. The statute does not mention tariffs. The legislative history shows Congress intended to constrain, not expand, presidential power. No other president in 50 years claimed this authority. The constitutional text assigns taxation exclusively to Congress. The major questions doctrine requires clear authorization for actions of vast economic significance. Under the framework this Supreme Court has established in recent years, particularly in cases limiting agency authority, the government's position should lose decisively. Chief Justice Roberts and the conservative majority have been aggressive in policing the boundaries between congressional and executive power. Yet the delay suggests something more complex is happening. It is possible the court is struggling with how to craft a ruling that strikes down the tariffs without creating immediate fiscal catastrophe. Justice Barrett's questions during oral argument focused extensively on the mechanics of reimbursement. The court might be considering whether to structure its opinion to allow for a gradual phase-out rather than immediate invalidation, whether to limit the scope of refunds to preserve some collected revenue, whether to provide congressional time to enact replacement tariff authorities through proper legislative channels. These are complex remedial questions that take time to work through. What becomes clear is that regardless of how the court rules, the structural damage is already done. If the court upholds the tariffs, it will have blessed a massive expansion of presidential power to tax without congressional authorization, fundamentally altering the constitutional balance between branches. Every future president will understand that declaring an emergency and invoking IEEPA grants nearly unlimited tariff authority. The power to tax, which the founders considered the most important of all governmental authorities, will have shifted from the legislature to the executive. If the president can discover taxation authority hiding in an emergency statute that doesn't mention taxation, what other powers might be discovered in equally ambiguous language across the massive federal code? If the court strikes down the tariffs, as legal analysis suggests it should, the immediate consequences are fiscally severe but constitutionally necessary. The federal government loses $2 trillion in projected revenue over the next decade, expanding deficits that are already on an unsustainable trajectory. Projected annual deficits would rise from 6.1% of GDP to 6.7% over the next decade. The debt-to-GDP ratio would climb from 120% to 126% by 2035. The administration is correct that losing these revenues creates fiscal problems. But the administration created this problem by building its fiscal strategy on constitutionally questionable foundations. The Supreme Court cannot save the government from its own poor planning by endorsing constitutional violations. The structural inevitability here is not about whether tariffs exist, but about how they come into existence and who controls that process. What the court's silence reveals is a system struggling with the tension between constitutional structure and practical governance. The Constitution assigns taxation to Congress because the founders understood that the power to tax must be accountable to the people through their most representative institution. But Congress has proven increasingly dysfunctional, unable or unwilling to make difficult decisions about trade policy. Into this vacuum, presidents step with expansive claims of inherent authority or creative interpretations of old statutes. Courts are then forced to choose between endorsing these power grabs or creating practical chaos by invalidating actions on which significant reliance has been placed. This is the trap that produces systemic fragility. When constitutional structure and practical governance diverge too far, when the mechanisms the founders designed no longer function as intended because one branch has ceased to effectively perform its role, the system begins breaking down in unpredictable ways. The Supreme Court's silence is not indecision. It is the sound of a system under strain, where every option leads to some form of institutional damage. Uphold the tariffs and damage constitutional structure. Strike them down and create fiscal crisis. The fact that this choice exists at all reveals how far the system has drifted from its intended operation. At this stage of the cycle, with fiscal pressures mounting, political legitimacy declining, institutional trust eroding, and economic performance deteriorating, the systems that should provide stability instead amplify instability. The Supreme Court's ruling, whenever it comes, will not resolve the underlying tensions. It will simply determine which kind of crisis we face next. If the tariffs stand, we face a constitutional crisis where presidential power to tax has been fundamentally expanded. If the tariffs fall, we face a fiscal and economic crisis where hundreds of billions in projected revenue disappear and thousands of businesses demand refunds while the government scrambles to impose replacement tariffs under different legal authorities. Neither outcome restores the system to healthy functioning. Most people miss this structural dimension because they focus on the immediate question of who wins and who loses in the Supreme Court ruling. Will importers get refunds? Will consumers see price relief? These are the questions media coverage emphasizes. But these are symptoms, not causes. The underlying cause is a governance system where normal legislative processes have broken down to such a degree that presidents routinely claim sweeping powers under old emergency statutes, where Congress deliberately avoids making hard decisions about taxation and trade, where courts are forced to choose between endorsing dubious power grabs or creating practical chaos. The acceleration happens faster than historical precedents would suggest because multiple fragilities compound. Trade volumes have already contracted sharply. Business investment outside of artificial intelligence has declined. Job creation has essentially stopped. Consumer confidence has plummeted. The federal debt trajectory is unsustainable even with tariff revenues. The structural fiscal crisis exists independent of the tariff question, but the tariff question has become entangled with the fiscal crisis in ways that make both harder to resolve. When the ruling finally comes, likely sometime in the next several weeks, as the court returns from recess and begins issuing decisions in February or early March, the immediate reaction will focus on winners and losers. Business groups will celebrate or lament depending on the outcome. The administration will claim victory or denounce judicial overreach. Markets will move based on implications for fiscal policy and trade relationships. But the deeper significance will be about which type of constitutional crisis we proceed into. Either we have dramatically expanded presidential power to tax, fundamentally altering the separation of powers, or we have invalidated the fiscal foundation of current government operations, forcing a scramble for replacement revenue or spending cuts or deficit expansion. Neither path leads to stability. The Supreme Court's 3-month silence is not delay. It is the sound of a system at the breaking point, where every option leads through some form of institutional damage, where the choice is not between good and bad, but between different varieties of crisis. Understanding this is essential to understanding what comes next. The ruling, whenever it arrives, will not resolve these tensions. It will only determine which crisis accelerates first and how the system begins breaking rather than whether it breaks.